Hey Colorado Realtors, I'm Scott Peterson. Thank you for joining me for another edition of Legal Bites. On today's edition, I'm going to be talking about a super hot topic. It's hot because it's pressing. It just occurred quite literally yesterday. This occurred. And it's also hot because it's been a continual hot topic in the state of Colorado and I believe throughout the entire country for many years. But big changes yesterday. I'm going to be talking about the new NAR MLS policy related to coming soon or pocket listings. So when I say hot, I mean hot. I jumped out of bed this morning and raced right in here to do this Legal Bites for you today because just yesterday the NAR Board of Directors adopted, or passed I should say, at their fall Board of Directors meeting out in San Francisco, they passed the Clear Cooperation Policy is what they're calling it. And what they're trying to address in their Clear Cooperation Policy is coming soon listings and pocket listings. And again, I've done a lot of talking over the years to many of you about coming soon listings, specifically as it relates to license law and kind of potential breach of fiduciary or self-interested coming soon listings where a broker maybe keeps the listing in their pocket, they don't fully expose it to the marketplace. And to the extent that that was ever harmful to the seller or the seller wasn't fully informed about that, could be license law violations. I've talked about it from a policy standpoint. I mean, I'm not a huge fan of coming soon listings. I think it does cut certainly against the grain of our expectations of cooperation, and I think full exposure to a marketplace is generally a good thing for a listing. So I've talked about it from a policy standpoint. Well, now it's MLS policy, and this, like I say, just was adopted yesterday. It's going to be effective January 1st of 2020, so coming up here in just a little bit over a month, or about a month and a half, it's effective, and it's mandatory May 1st of 2020. So as part of adopting the policy, they acknowledge that even from a technological or data field standpoint, there's some things that the MLSs around the country might need to do in order to fully implement this brand new policy. And so they made it effective January 1st, but it's going to be mandatory across any realtor-owned MLS in the United States of America effective May 1st of 2020, so just next year. Going to be in every case. So what does the policy say? That's what we want to get into here. And basically it's called MLS Statement 8.0 is how they adopted it. And what it says is within one business day of marketing a property to the public, the listing broker must submit the listing to the MLS for cooperation with other MLS participants. Public marketing includes, but is not limited to, flyers, displays in public windows, yard signs, digital marketing on public-facing websites, brokerage website displays, including IDX and VOW feeds, digital communications, marketing, email blast, multi-brokerage list sharing networks, and anything that is generally available to the public. So what does that mean? It's pretty darn broad. Public marketing, the definition of public marketing is very broad. It's anytime it's being exposed outside of what I would say would be an internal brokerage firm listing. So they've given an exception to a situation where a brokerage firm wants to list or share within that specific brokerage firm's marketing. There's an exception for that to this rule. But if your seller wants you to put a yard sign in their front yard, if they want to syndicate it somehow, or they just want to maybe put it on one of the syndication sites for a period of time prior to putting it into the MLS, if they want to distribute flyers in any way, if they want you to use your social networks, maybe blast out a Facebook post about your new listing, anything that could be considered marketing to the public, and again, from a very broad definition, that would include a lot, that listing then has to be entered into the MLS within one business day of that public marketing taking place. So that's a very significant rule change with regard to how many brokers have been addressing what we would describe as pocket listings, or more commonly in Colorado, I think they'd be referred to as coming soon listings. Very significant change for the marketplace. and the state of Colorado generally, and lots of implications potentially. Is it going to be the end of coming soon listings? I guess we'll see. It's, you know, time will tell how the market sort of reacts to and adopts this rule. But again, there is no wiggle room with regard to the MLS from a mandatory standpoint adopting the rule effective, like I said, as early as January 1st, but it's mandatory for every realtor-owned MLS in the United States of America as of May 1st of next year. So be thinking about how you're doing these things. You're going to be maybe needing to have a little bit broader discussion with your sellers. In some cases, sellers, you know, they want an early yard sign to get some marketing energy going, or maybe they want, in some cases, to push the thing out to syndication websites. Maybe they think they need additional time for staging and such, but they want to, you know, get some early buzz going. You're going to be very, very constrained as it relates to this new MLS policy. So be mindful of that, and make sure you are aware of your MLS rules. I'm sure you're going to be hearing a lot about it directly from your individual MLSs around the state of Colorado. But like I say, no more wiggle room when it comes to coming soon listings from the moment they've been published in any public domain whatsoever. They have to be then entered within one business day into that MLS in the marketplace. So anyhow, if you have questions about the new policy or anything else for that matter, check out our car legal hotline. And thanks for being here, and we will see you on the next edition of Legal Bites.